Any mention?
May it please, Your Lordship. Your Lordship, I beg to mention item number 26, Your Lordship. Item number 26, Your Lordship. I pray that the matter may come up after 2 weeks, Your Lordship. I'm for respondent number 4, Your Lordship.
You have objections? Why?
Your Lordship, the conducting counsel is having some personal difficulty, Your Lordship.
You'll be the new conducting counsel now. From next time the case is called out. Okay? Yes, just after 2 weeks. That current counsels are available, yes.
So, Your Lordship, I want to mention for item number 12, as the petitioner has not come from Guwahati, somebody died, so he could not sign the affidavit. Number 12.
Your Lordship, number 12 is in the order column.
Orders, let the order be passed. You can't mention it now. We'll pass orders when the matter is called out. Mention the hearing matters, okay? Yes.
Your Lordship, I beg to mention item number 28. Your Lordship, the conducting counsel, Mr. K.C. Gautam, is on leave, Your Lordship.
28 to 42 are connected matters.
42.
28 to 42?
Yes, connected matters.
Connected.
Which matter is this?
So this is pertaining to
Feedback commission, work charge.
Feedback commission.
I've not seen Mr. K.C. Gautam for a long time.
Your Lordship,
Is he in the country?
He's in the country, Your Lordship. Just out of state, Your Lordship.
20 to 42, they all same
Last
matter.
connected matter here, Your Lordship.
Same issue.
Prayers on behalf of Mr. K.C. Gautam, the conducting counsel in the lead matter for some accommodation. He's on sanction leave.
Leave, Your Lordship.
As the conducting counsel on sanction leave, this after 1 week.
2 weeks, Your Lordship.
2 weeks, okay, yes. Yes.
Abridgment.
Right, Your Lordship.
Lordship, I beg to mention item number 27 of the hearing list.
27,
Lordship.
Why?
Lordship, some difficulty, Lordship.
No difficulty. You guys other side. It's fixed today. Miss MS Kolni. Where's MS Kolni?
Your Lordship, she's on legs, Your Lordship.
What's the problem?
Lordship, senior counsel has some difficulty today, Lordship. Any day, Lordship, this week.
No. You take consent first. You're taking consent? No. We'll call it out. You wait. If we can finish it, we'll finish it off, even without senior counsel. Yes.
May I
Yes,
please, Lordship, I
Ms.
beg to mention item number 24, Your Lordship. Let this matter be taken after 2 weeks, Your Lordship.
After?
2 weeks.
We'll give you 3 weeks. Okay. Yes.
Much obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 25.
For Mr. Jha?
Yes.
Yes.
Your Lordship.
Who's appearing other side? This matter was heard, I think.
It was at that OVC matter from Assam.
Yes.
The BSF.
1 week. Okay.
Much obliged, Your Lordship.
Call out the list.
Item number 20 and 21 is analogous matter regarding the managing committee. I need some instruction from my client from Garo Hills.
What instructions? Yes.
20 I'm there.
20 and 21 I am there.
20 I'm there.
Nothing remains in the case.
After 1 month, I think everything will be over.
What do you mean after 1 month?
Because the committee terms is still October. Yes, sir.
Oh, that's why you are taking time.
No, I'm just taking some instruction whether any new committee.
Now it's August.
Whether any new committee was constituted or not constituted. That's what I want to ask.
Please that these two items are 20 and 21.
20 and 21.
20 and 21 be adjourned, able to obtain instructions with regard to the reconstitution and managing committee. Prayers allowed list after 2 weeks. Just after 4 weeks. Yes.
4 weeks.
Yes, take your time. Follow now.
Item number 1.
Yeah, caveat has been found. Yes, in the house. We have sought copy of it.
Yes, my lord.
Yes.
My lord, may I take it up tomorrow, my lord. The
You
counsel is from Guwahati, my lord. The caveat is from Guwahati, B girl. So, my lord, she has requested me to appear, my lord, to fix the matter tomorrow, my lord.
So you take notice.
We have already served. Copy.
Okay.
Caveat may be.
Caveat. I've never seen such a thick caveat petition.
Yes, they've annexed the copy of the
It's thicker than their petition anyway. MS Ardata, we're going to caveat number 41/2023 is present. We have a caveat stands discharged. Yes. Now in the main case, yes.
My lord, in fact, this is the second round of litigation before this court. Here, the respondent had filed a suit for declaration and for also for eviction. Now, in the intervening period, as your lordship is aware, the judgment of the Supreme Court, Kintewa came about because both the parties here belong to the Panar community. Now, as per the judgment of the Supreme Court, the district council courts will have jurisdiction only over persons who are of that area.
Yes, so
we filed a petition before the trial court saying that this court has no jurisdiction.
Cause of action arose where?
Cause of action arose here, location of the suit property also.
Then?
But my lord, if your lordship will see the judgment of Kintewa Court, this has to be dealt in detail, my lord, because there are around 70 to 80 cases pending in the district council courts.
I'm aware of this problem.
Yes.
The thing is that it's like this now. We cannot take that, it has to be that a person ordinarily resides in that place in a different district. Not that just because you're a Panar and you haven't addressed it so long that you can take recourse to this and say that the court has no jurisdiction. I don't think that's be the correct.
That's why we have to this issue has to be. Even I am not for this judgment, but since it's a judgment of the Supreme Court under 141.
No, if you read paragraph 4, it says like that only.
Paragraph
Like for the tribals residing in a certain district.
We'll just see, we'll have just a quick glance at the Kintewa Court judgment. You'll also just have a glance because this is how the Supreme Court has interpreted.
Yes.
At page 489, paragraph 5.
Yes.
Towards the last. As a result, a district council constituted for the purpose of deciding disputes has jurisdiction only in respect of tribals who belong to the scheduled tribes within such area for which the said district council is constituted. It would have no jurisdiction where one of the parties belongs to another area which is under the jurisdiction of another district council.
So now we have to split here.
Yes.
Now belongs to another area. He can be at Panar also, but he might belong to Shillong.
Now, if your lordship will come to page 12 of the petition, there's a plaint.
Plaint, page 12.
Yes. Now, the plaintiff is a prominent businessman and a permanent resident of Larimbai, East Jaintia Hills District, Meghalaya, and presently residing at Madanriting, Shillong, East Khasi Hills District, Meghalaya.
Okay, anyway, we will issue notice.
This is an important.
But as far as this court is concerned, I think we will go by that. We will try to interpret it in such a way that distinguish that
That's why this
is a tentative view. That already residing. Yeah. Now you already residing this place doesn't mean that you might be like from
not residence. Well, the Supreme Court has belonging.
Belonging, yes. You can belong here. Yes. Like myself also, I ethnically, whatever. I'm not from Khasi Hills. So maybe 400 years ago I came, but that's a different proposition.
Because my lord, in the district council now, as of now, even cases of Khasis and Mizos and between Mizos also, they're being entertained.
No, they'll have to go to the regular court then, if it comes to that extent.
If it comes to that.
Yes, I heard Mr. T. Honorary Counsel for the senior counsel assisted by also for the petitioner issue notice returable in when can you come and we do admission hearing and finish it off?
Yes.
2 weeks.
2 weeks.
2 weeks, yes. Ms. S. Thapa and Ms. Adata are present on behalf of the cavities. This accordingly on so and so for admission hearing.
Item number 2.
Yes.
May I please, my lord? My lord, by this application, the petitioner before your lordship is aggrieved of the delay on the part of the state respondent. Delay on the part of the state respondent, yes, to accord approval to the newly constituted MC of the school.
When was it constituted?
Constituted 2022.
And when was it sent for approval?
My lord will come with me to page.
The applications of 17th May.
You sit down, sit down. Let
approval is at page 105, my lord.
Seeking approval?
No, the existing MC.
No. You've reconstituted, right?
Yes, newly constituted at page 17, my lord.
Page
17.
So
103, my lord. 103.
Okay. Yes. What is another manuscript that has been approved instead of yours?
No, my lord. What happened in this case? The petitioner is a trust.
Okay.
For the purpose of administrations and looking after the affair of the schools. Petitioner number 2 is the owner of the trust. I mean the great settler. The petitioner number 2 is he has founded 3 schools. In the year 1963, he established LP school, run and administered or bear all the expenditure from his own pocket. Now, subsequently, in the year 1964, he upgraded the LP school into ME school.
Okay.
And thereafter, in the year 1980, the petitioner number 2, who is the founder, upgraded both the LP and UP into
what happened after that?
Schools. And on that year itself, the government has recognized and extended some financial assistance to the petitioner. One thing, my lord, you will appreciate that all the 3 schools were constructed and built in a place or in a land purchased by the petitioner himself. In one way, I may submit, my lord, the school of the petitioner is purely a private school run and established by the petitioner. Whereas the Dabasinong, which is the respondent number 17, they have no role to play. And after, from the year 1963 until date, the petitioner number 2 is the owners, and so he is holding the post of secretary.
Why are you
in the year 2023? For the purpose of a future prospect or admission of the school, of his school, the petitioner desired to create a trust, and he created a trust in the year 2003 during the month of April. After creating the trust in its apex body, the board of trustees has held a meeting and decided to take over the admission of the school from the.
Now the school was managed by whom in the intervening period?
In
by
the
village themselves?
Yeah, by the
by the villagers.
The managing committee under the nominated by the petitioner number 1. The petitioner number
that means that he was the sole sponsoring body.
He has the sole sponsoring.
Okay, then what happened after that?
Then following the formation of the trust, my lord, on 10 May 101, page 101. Decision of the board of trustees.
Okay, fine. Now, what do you agree with at this stage?
After taking this, after this resolution, the petitioner intimate the resolution to the respondent number 3, requesting him to prematurely dissolve the existing MC and to approve the newly constituted.
On the ground that this was
on the ground that the admission of school was taken over by the.
What is the reply?
The respondent number 3, pursuant to the request made by the petitioner, visited the site of the location of the school, had a meeting in between, comprising the MC of the new MC along with the member of the village, and take a decision that the approval will be done subject to the justification or subject to the no objection issued by the village Dorbars. So, pursuant to that, the village has held a Dorbar on 26 June 2023, my lords, whereby they have expressed their no objection to the transferring of the admission of schools. And then, my lords, subsequently on 1st June 2023, there are a group of 14 members from the village, individual persons, raise an objection, file an objection before the respondent number 3, saying that they have objections against the proposed transfer of the management of the school unto the trust or to the private society. So owing of that, the respondent number 3 is keeping the matter on hold by asking.
That's it. Now what happened? Who's running the school now?
The school is running by the petitioner number 2, the owners, along with the.
Till now?
Yes, till now.
What about that letter you showed just now, page Constitution 2025, Annexure 10? This is whose managing committee? Page 105.
Page 105. This is the existing managing committee. As of now, this committee is running.
It's by you?
Yes. Headed by the petitioner. President is KP Moton, who is a petitioner number 2. Right from the inception of the 3 school, he is holding the post of secretary.
Yes, you're paying for the state.
I know. My lord, may kindly come to page 134. It's a letter sent by us, by R3, which is the district school education officer. Page 134, annexure 19. It's a letter dated 20th July 2023. Their application is of May 2023. In this letter, we say that we are unable to ascertain the real owner or owners of the school, and therefore we have requested them to furnish the facts in papers
You furnished it in 2 weeks. Have you furnished the facts?
Yes.
To the school? To the authorities?
Yes.
I'll need to seek instructions.
Seek instructions, yes.
And
your name?
S. Ain.
S?
Ain. A-I-N.
Heard Mr. S.M. Suna, the contributor, issue notice, MS so-and-so, appear on behalf of respondents number?
1 to 3, it seems, my lord. State respondent.
1, 2, 3.
Then 4 to.
No further notice required, please respondents. They should take steps for issuing the notice to remaining respondents within 3 days, just after 3 weeks for accurate instructions.
Great.
1 week, my lord.
Sorry, can you take steps? Will they be served within 1 week? Very thoughtful.
No.
Let them come instructions first.
And can we file a counter affidavit in them?
Of course, that's for affidavit or for instructions after 3 weeks, yes.
Great.
Duly obliged, my lord.
Item number 3.
Yes.
May I please, Your Lordship? This matter is related to upgradation of an assistant headmistress to the post of assistant headmistress in a deficit school.
Upgradation of
assistant teacher to the post of assistant headmistress in the high school. And the petitioner, before Your Lordship, is the senior most assistant teacher in the school, and she joined her duties in 1992. And the managing committee by resolution upgraded the petitioner to the assistant headmistress on 1/3/2023 and forwarded to the director of
What do you want now?
The director, Your Lordship, rejected his approval here to the post of Your Lordship on the ground the B.Ed degree.
Where's the impugn order?
Impugn order, Your Lordship, 2 letters, page 27, Your Lordship.
Yes. Oh, you don't have B.Ed degree?
No, Your Lordship.
Then?
Your Lordship, I joined in 1992. At that time, B.Ed degree is not required.
It's not required?
Not required at that time, Your Lordship.
You sure about that?
Lordship.
Yes.
Page, Your Lordship, 2 impugn orders, page 27. Your Lordship got it, Annexure 10.
Yes. What is your name?
S. Islam, Your Lordship.
Your name?
S. Islam.
Mr. S. Islam counts. None appears on behalf of the respondents. You've served notice? Where are you? If you appear for the state, you should be here. Are you in Guwahati?
Yes, madam. Today I am here.
Yes.
Respondent 120.
Yes, sir. Mr. S. Islam will issue notice. MSP are called present and accept notice on behalf of respondents 1, 2, and 3. Steps will be taken for issuing notice 12 or 4 in 3 days, just after 3 weeks. Yes.
There is IA for miscase for interim order, Your Lordship, for state.
Interim matter shall be taken up on the next date. Yes, shall be considered on the next date.
But the status may be maintained, Your Lordship.
No,
we are holding the post.
Let them come first instruction.
Yes.
Yes.
Please, Lordship. See, here I was appointed as a contractual teacher in 2011, and there was occasion when it was not extended.
You're contractual?
Contractual. It was not extended. Then I approached this Honorable Court, which is annexure page 21. In page 21, the Honorable Court has passed an order saying that I may continue. Then I continued. Then,
you shall continue?
Yes, 21.
Where is 21?
Page 21, running page. Annexure 4.
In the meantime, till 20th.
In the meantime,
till 28th of February 2020.
Yes,
That's
but
it.
So anyway, they have considered that I made a prayer before this Honorable Court. Lordship passed an order. Page
So finally dispose of the case, yes.
24 order was passed. The case became infructuous because they have considered that they will retain me in the service.
Basis, yes.
Thereafter, what happened? By impugned order. Now, 2020 to 11, 2017. In this impugned order, they say that pursuant to the order so and so, in conformity with the directive issued by the Honorable High Court 2/11/2017, I was terminated with from service on the ground that I am a tainted teacher. So this fact was never brought before this Honorable Court when I filed writ petitions. Now my
contractual, what tainted means what? You didn't go to the selection process.
So tainted, yes. My only ground is that since you are removing me from the post as saying that I'm a tainted teacher, stigma is there. Yes. So you could have given me a chance to showing cause and hearing. That is my limited prayer only.
No, what strange, Mr. Shulai.
Lordship.
If they're contractual teachers, they've never gone for selection. What do you mean by tainted?
May please ask your Lordship. If Lordship kindly come to page 23.
20?
23, your Lordship, Annexure 6. Yes. Lordship, kindly see that contract basis only on 59 days only.
That's what I'm saying.
No, fine. Right, but then contractually, if you terminate the termination semester, there's no stigma. But now you stigmatize them. Did you ever go for selection?
No, I was never appointed pursuant to the selection.
Lordship, it appears if Lordship kindly come to page 25. 25. It appears, your Lordship, he is a candidate who fall within that tainted category as per that order.
Was he ever selected?
Never selected.
Then?
This one,
Lordship, it's not clear. It is not clear, your Lordship.
You initiate criminal proceedings against him?
Yes.
Then Lordship will have instruction in the matter.
Take instruction, yes. Here, Mr. M. Kureishi as counsel for the petitioner. If you notice, Mr. N.D. Shulai, Leonard EAG with so-and-so is present, except notice on behalf of all the
for all, your Lordship.
No further matter.
Well, in this case,
2 weeks for
serious case also. Just to continue, allow me to continue in the meantime.
Yes, no.
Till next date.
Contractual, just a matter of 2 weeks for instructions.
Apply, your Lordship.
Item number 5.
How is it possible? If good.
Maybe, your Lordship, that.
Yes, start.
Please, your Lordship, I pray for your...
Start. How many times has been adjourned this matter?
Lordship, I seek your commission for today.
Your Lordship, they've already informed us. Your Lordship, they've already informed us in the morning.
Doesn't matter, this is for admission hearing.
Yes, your Lordship.
See, we shall... Since 28th of April, this matter is for admission hearing.
Yes, your Lordship.
Lordship, I'm praying that this...
So does that mean you don't have any other objection? We'll admit it for consideration?
Your Lordship, because actually my senior said that he's here, your Lordship, but he's in... because they've informed us in the morning, so that's why we've accommodated.
This is a matter of the 3 weeks for admission hearing on the prayer of MSE 1. Yes.
Much obliged, Lordship. Item number 6.
This is the contempt application with regard to doctors. And the last order,
yes.
Losses are directed that no affidavit is filed, my lord.
Where is he present today?
My lord.
The responsible officer will call for his appearance.
My lord, I had a talk with them. My lord, what has happened here? The policy review will take some time, my lord, because...
Let the officer come. Just give the name of the responsible. One officer can come from Ministry of Home Affairs.
Well, the only thing what we are proposing, my lord, I told the department also, if this particular petitioner, my lord, he is granted relief, my lord, without awaiting for the review of the policy, my lord. Because review of policies, there are lots of cross objections to the policy, my lord. And that is why they are not able to finalize
it. No, Dr. Mozika, we're going by this order, last order. It's a judicial order. We are bound by it also. Give the name of the responsible officer. We'll pass orders in the course of the day. Unless you want Mr. Bhalla to come. He's got extension for another year now. Yes.
But only I'm praying for one more opportunity.
No.
But in fact, I had to in the entire date. But entire last week.
Who is the joint secretary? Ministry of Home Affairs.
I'll find out the name. I'll give the name.
You give the name. A competent officer.
What I was praying, my lord. We can give, as far as the particular petitioner is concerned, my lord. We can, what he is asking for, we can accede to that, my lord.
Then why you not acceded till now? Why you want this matter to come such a stage where now we have to summon Mr. Bhalla to this court?
But because ITBP and Assam Rifle, my lord, who are operating in far-flung areas, my lord, they have serious objection to the policy, my lord. Because what is happening, my lord?
That doesn't concern the court. It's just that if you can't think of something, he's been suffering how many years, Mr. Mamdar?
My lord, we have been fighting in this court since 2018.
My lord, he's already in CRP. He's posted in Guwahati, my lord.
Prior to that, we were in another writ petition where liberty was granted to them. That did not take place. We came back in a writ petition. The policy was framed per orders of this honorable court.
My lord, he's in Guwahati, my lord. It appears that he's obtained some stay order from Guwahati High Court also, my lord.
What had happened is, my lord, there are 5 petitioners in this contempt petition who were original writ petitioners in the original writ petition. Now, one of them was posted at Guwahati. Pendency of this contempt petition, he was sought to be transferred out from Guwahati. We moved a writ petition, there is a stay order there. The Assam Rifles is, as of today, they have filed an affidavit again in the Guwahati High Court saying we are not implementing the policy. Now, this requires to be stopped. I'm not on the secretary or the ministry level, my lord. What happens is till they relook into the policy or do something about it. That is another aspect, if they want to relook into it. But as of date, the policy that exists, the secretary does not say that we are not implementing it. It is only the Assam Rifles who stand up to say in every court, including the Manipur High Court, including Meghalaya High Court, the Guwahati High Court, that we are not implementing it. Do what you want. We'll pass our orders. That is the attitude we want stopped. The policy, if they change, allowing our transfers to anywhere in India, if the policy changes, we are bound or we challenge it. Existing policy, Assam Rifles takes a stand on affidavit before this honorable court saying we are not implementing it. That is what we are against, my lord. That is where the contempt arises. The persons who have filed these affidavits, earlier affidavits, initially they wanted to file an affidavit on behalf of the ministry also. We objected to it. That this is a contempt petition. One cannot do that. Now nothing has come from the ministry, and the last affidavit lordship will find, which was filed on 17th of May, after which this order of June had come on. If lordship takes up the last affidavit, filed on 17th of May, page 5, para 12.
Yes.
Lordship will find that the deponent states that as of now the policy has not been implemented.
Yes.
The ministry does not say so, the secretary doesn't say so. It is the DGAR who says we will not implement.
You give the name of some officer.
Well, that's not the case, my lord.
You give the name of some officer. We'll pass orders.
Well, only one. I'm earnestly praying for one opportunity, my lord. We will try to accommodate him, my lord. Well, a little longer, my lord.
I would not put him in difficulty.
Yes, as far as he is concerned, he is protected by the.
By order dated 6/7/2023. This court had directed that an affidavit was to be on board within 4 weeks, feeling which the concerned officer from the Ministry of Home Affairs was to be present in court on the next 6 weeks to clarify the matter. Next part. Today, Dr. N. Mozika, TSG with so-and-so, submits that the case of the petitioner is under active consideration and prays that the presence of the Ministry of Home Affairs, it will not be required at present. Stop. He prays for and allowed. We'll give it 3 weeks time. 3 weeks time.
You can accede to his prayer, my lord. So then at last.
There are five petitioners here, my lord.
No? The constitution to accede to the prayer. You not say that because a court order. You have to accede to the prayer. It's a question of this is a question of violation in this contempt. No? He prays for and allowed 3 weeks time to resolve the issue. Yes, that is accordingly concerned. Otherwise,
if they don't come up with something on the next date, my lord,
we'll pass orders.
Item 7.
Yes, Mr. Kumar.
My lord, item number 7 and 8, the contempt petition, my lord, we have received the copy of affidavit in opposition, my lord.
Yes.
SLP is pending before the Honorable Supreme Court, my lord. It was last listed on 14/7. And 4 weeks time has taken by the petitioner, my lord. So this SLP will listed after 4 weeks, my lord.
My lord, a similar matter was closed by lordship, my lord.
Closed?
Because there is no specific timeline given, my lord, and they are entitled to interest if there is a delay, my lord. Just last week, your lordship closed the matter.
See, Mr. Kumar, if there is no specific timeline given, then we can
verify.
the same order.
Same order.
Mr. Kumar, you are aware of this order passed by this court on 1st of August 2023?
No, my lord.
In contempt, you furnish them a copy. This is a matter after 1 week. Learned DGSG to supply copy of the order passed by this court in contempt case number 77 2022 in writ appeal number 13 2019. Yes, 7 and 8.
My lord.
Yes.
Item number 22 and 23 are also connected matter, my lord.
Okay, let's after 1 week.
6, 7, 22, 23. Sorry, 7, 8, 22.
7, 8, 22.
7, 8, 22 and 23, my lord.
Okay.
DPO, your lord.
Item number 9.
This matter, we have received the written statement filed by the defendant, my lord. But it 6 weeks time to file our suggested issue.
Maintainability is over, correct?
Yes.
Over. Now,
that limitation part's over.
Limitation part is...
That's over, my lord.
That order has been passed by...
Yes.
Already
That has been passed. That has been passed, my lord. My lord has already held that the petition is within time.
Okay, then...
I want to submit my written statement.
Written statement has been filed. We have respondent number?
Respondent number
Respondent
one.
number one.
You receive copy?
Yes.
What is your ground of challenge?
It is only...
We have said that, my lord, yes, with regard to the... We had said that, my lord, the mock test results were never deleted at the time of even making the actual counting, because of which, my lord, that had a bearing on the...
Yes, party to file suggested issues the next day.
There are other respondents also, my lord.
Yes, you have respondent number? 5. No, Mr. Sangma? From the written statement we filed, we have respondent number 1. Same taken on board, since input on record, kept in the record. Stop. Mr. C. Sangma for number 4, Mr. SD for number 5, number 2, and Mr. C. Sangma for number 4. What about number 3? Who's number 3?
3 gold star.
Who's golden star? Long. Have you appeared?
No, my lord, they have not appeared. They have not appeared, my lord.
Is he a necessary?
He's been duly served.
No, yes, not a question of service. Is he a necessary party?
No, my lord. Because only the law mandates they are required to be a party, so we made them a party.
Yes. No, none appears for Ms. SDM house number 2. Submits that no affidavit forthcoming from their side. Mr. CCT Sangma on behalf of number 4 also submits that no affidavit will be filed. None appears on behalf of the remaining respondents. This is the matter after 2 weeks for highly suggested issues by the petitioner and by the spot number 1. You file the issues.
Item number 10.
Yes.
But in this case, we have already filed affidavit, my lord. On the last date, my lord, petitioner had declined file and rejoined. My lord, we can have this matter next week for hearing.
For hearing with a contempt, we'll have it for, not for final hearing.
Or for admission.
That is the rule under the High Court rules have to issue.
Yes, we have to first see whether contempt is made out or not. We'll have a hearing then. After the hearing, then we have to issue contempt notice.
No.
Yes, list the matter for hearing after 2 weeks. On the prayer of the parties.
11.
Please, Your Lordship. Your Lordship, I pray for some time to file an
Why?
affidavit in this matter.
Quite a good number of time they have taken. Time, my lord.
What's the matter about?
This is a matter, my lord, of pension benefits of the
pension.
Yes,
For regularization.
regularization and pension also, my lord. This matter was filed in the month of April, my lord.
Can you give them how many times you've taken?
Your Lordship, this will be the 4th time.
We'll give you, I won't say last opportunity. 2 weeks further time as plates granted to the state response file affidavit. It is expected that on the next date the affidavit should be on board.
Obliged, Your Lordship.
Item number 12.
This imposed cost, and from the concerned respondent, we'll take out the cost from if you don't give instruction and file affidavit. Yes, Mr. Bora is not here.
No, sir.
Yes. What instructions you're supposed to receive? That they have said that all terminal benefits have been paid to you. Correct. And now you're supposed to instructions whether they receive everything or not.
Like area pay revision, 50% has been received. 1,20,073 rupees. But gratuity has not been received. Only 3,50,000 has been received, but that is not the actual gratuity.
What is the actual gratuity amount?
May it please your lordship.
You file, can you put in a small affidavit?
Lordship, affidavit has already been filed. Your lordship, in fact, lordship, I am seeking for dismissal of this writ petition on the ground of concealment of material facts, your lordship.
Yes. Well then.
Lordship, kindly come to.
Pay, not gratuity.
Then see para 8. All deals with a revised scale of pay that comes in have been sanctioned and paid to the petitioner.
Lordship, yes. And gratuity also she has, the petitioner has received an amount
Then
of.
I will spare her. We'll dispose of this matter.
Sir, please give relief and dispose of, sir.
Relief's already been given. You've got all the money. Then what more do you want?
No, only 3,50,000 is
That's
not
what
the
you're
actual
entitled
gratuity,
as per the
sir.
revised pay.
That is not the actual. As per revised pay, then my.
What are you supposed to get? How much are you
I
supposed to
should
get?
get revised
Of how much?
gratuity also.
Of how
Now
much?
it has been
That is
raised
the
to
revised only,
20
That
lakhs.
is the revised only.
Sir,
3,50,000 plus.
It has been raised to 20 lakhs. He retired in 2019 from.
See, the thing is that
Lordship,
in
kindly come
exercise
to
of the
page 10
powers.
of the state affidavit.
No, sir. State is doing injustice, sir, to me.
Page 10, annexure 2. Lordship, there was an existing rate of 2.50. Now it has been raised to 3.50. This is the rate of which the petitioner has got it.
Where's the petitioner now?
Petitioner, he's coming from Guwahati, sir. He's sick.
Why he's misleading the court then?
Then Lordship,
No,
kindly
he's not
come to page
misleading, sir.
13, annexure
He's
2
not
of the writ
misleading the
petition.
court, sir. Annexure
2, page 13, Your Lordship.
See.
Because 3,50,000, what amount is of gratuity is it, sir? As per notification I have seen, it should not exceed 20 lakh rupees now.
20 lakh rupees.
And he
not
has got
exceed
revised
20 lakh
pay.
rupees. Yes.
He has got revised pay. Then he should be given revised gratuity also.
Annexure 2, Your Lordship, page
This is
13.
very much injustice done.
3,50,000, that was the amount received.
On what basis it was calculated? It should be calculated as per gratuity rules.
Why do you write this letter why do you write this letter at page 14 to the governor then? What kind of person is this? After receiving, you signed it in 2020.
For
you
the
received
balance
3.5
amount.
lakhs. Then you write to the governor that I have not been paid. I've not been paid my revised DRG and arrear pays. Why should you write to the governor?
That is before he got at a later stage the revised pay of 1,20,000. Writing to we can write, sir. We can ask for a write every time, sir.
To whom?
To
the governor?
persons concerned. So he
Why
has done to
write a letter
governor.
to the governor? Why you like what?
Maybe
The other methods
as
to
a
get
teacher,
relief.
he might have thought better to write to the
No,
governor.
it's just you see what your client is doing. He's misleading you, and he's trying to exert pressure by writing letter to the governor and getting a petition filed.
Maybe he made a mistake, sir. Because
What mistake?
He's a layman.
He's a layman. He's a very smart layman. He's been working for a long time. Will inflict cost.
He was a teacher, Your Lordship, not a layman.
You pay cost. You take instructions within 2 days, or will inflict cost. As per affidavit, you've been paid as per the revised pay from 2.5 to 3.5 lakh.
And that also, that fact has been
MSc
concealed, Your
Rahman, is to obtain instructions within 2 days. That is impose cost, yes. He's not a very clean person. Writing to the governor, he knows how to write to the governor. Long letters.
Lordship, I'm appearing for respondent number 5.
Okay, record first number 5.
13.
Within 2 days. Listed on Thursday.
Lordship, in this matter, the respondents are yet to file their affidavit in opposition. And as per the last order, Mr. S.K. Hassan had entered appearance for respondent number 8 and undertook to inform the respondent number 7.
He's informed number 7.
Yes, Your Lordship.
Yeah, paying for him also.
Yes.
What is your name? Sorry?
I'm Rahman.
Oh, M. Rahman, yes.
Represent.
Yes, sir.
And for
1 second.
This matter pertains to misappropriation of funds. And after filing of the complaint with the PTO also, funds have been released to the Village Employment Council. During the pendency of the litigation, further funds may not be released by the VC. Complaint pertains to misappropriation.
On what? When complaints filed when?
Now, the complaint was filed on 21/11/2022.
Too late in the day now.
Page 12.
See your cause title. Apparent malpractice, favoritism, and manipulation. Committed apparent. Apparent means what? By your estimate that someone's doing some hanky-panky. Can you pass interim orders?
Number 6 was either there. It is apparent because even after lodging of complaint regarding misappropriation, the respondent number 6 did not take any action on the complaint and he released further amounts to the Village Employment Council during the pendency of the complaint. And subsequently, after we moved to this Honorable Court, a so-called inquiry was supposed to be held, but it led to assault, whereby this Honorable Court was compelled to direct the Deputy Commissioner of West Garo Hills to make sure that such incident never takes place.
Then what happened after that?
After that, my lord, no inquiry has been made. Nothing is being done.
Let them appear first, 7 and 8. MS M. Rahman submits today that she will be entering appearance with House number 7 also. Stop. How much time will affidavit?
3 weeks time, Your Lordship.
2 weeks time, give it, and Stop 2 weeks time granted for affidavit. Similarly, 2 weeks time for the state response also. The order is already there. The order is already there, Ms. Agarwal. The order is already there on. The earlier order is already there. So you don't see. It's already there. So you don't have to have any apprehension. This order. That order is dated 1905.
1905, my lord, your lordship had directed the DC West rules to ensure that no further assault takes place. But so far as release of funds, it's not there.
You file, especially BDO, you file.
Please, Your Lordship, steps have been taken upon the respondent number 5. So the status report is awaited, Your Lordship.
We'd like to file a small affidavit also, my lord.
And Your Lordship, in the meantime, the miscase may be considered, Your Lordship, for the stay of the... Yes, Your Lordship. Because, Your Lordship, on the last occasion also, the Learned Counsel has brought in before the court the proceeding with regard to the appointment of the respondent. However, Your Lordship, as per my instruction, there was no recent proceeding with regard to the election of the Gambura, Your Lordship.
There was, my lord.
But as per my instruction, there was no recent proceeding, Your Lordship.
The instruction
and Your Lordship,
gospel truth,
if Your Lordship would see... No notice was issued to me also, Your Lordship.
But still, petitioner was present in the meeting.
That's the only thing that prevents this court from issuing your hearing your term. You file when are you going to file affidavit? Within 2 days?
No, not 2 days, 2 weeks, my lord, at least.
1 week, you already have instruction.
10 days, my lord.
And if Your Lordship would see the impugn order also, Your Lordship, it was only passed in based on the whims and fancies of the district council, Your Lordship.
The 5
it was not based on the
Mokibul Mola.
Yes, it was not based on
See,
the public.
resolution number 2, resolved unanimously that C. Mokibul Mola, son was elected and accepted on the post new Gambura of village Jugir Jhar with effect from 30th May 2020 afternoon.
And he has not raised any objection to this, my lord.
But if Your Lordship would see the impugn order also.
He is there in the meeting.
My lord, his photographs are there.
Sofikul, no.
His photographs.
Khan Bahadur Sheikh.
His photographs are there, my lord.
Here?
No.
Let it be brought into the court, Your Lordship.
We'll file an affidavit in 10 days, my lord.
Mr. SD submits that.
They are trying to enter through back door, my lord. They are trying to enter through back door. If they are ready to face election, we are ready to conduct the election, my lord. Let them face the election. You cannot come back door, my lord.
You face election?
No. That means they have
you face election or not?
Are you ready to face election?
No, Your Lordship.
Then, my lord.
At this point of time, I'm not ready for that, Your Lordship.
Then how can my lord
start canvassing now?
Let
so let the term get over, then he can do election.
First, Your Lordship.
Mr. SD, please was allowed to file a short affidavit when we record the resolutions and of the public meeting showing the results of the election of Gambura to village Jugirghar. Jurij-Har. How's it?
Jugirghar.
Jugirghar.
Let it be 10 days, my lord. I'll try to file it.
Yes.
Your Lordship, stay.
No stay. The resolution is very clear. How many people signed that? A lot of people signed that, if it's correct, which you can dispute.
Let it be a fresh election also. We don't mind, my lord.
It'll come to that next order, next day.
Obliged.
Yes.
My lord, this is the case where, my lord, the notice has been issued by this case on the basis of the false information given. And now, what I am concerned, Your Lord.
Mr. Paul will be again.
The Paul in Delhi.
My lord.
My lord, what I am concerned, my lord, because after taking this notice, what they are doing, they are in a deliberate disinformation campaign in the university, then the entire selection process is under the scrutiny of the court. Whereas the information furnished by them are all false.
Then we'll dismiss it.
We have the details from where we got the information.
My lord, I have formed records, I have prepared a chart.
Let them file an affidavit.
My lord, no, I will not file affidavit. This cannot be shared, my lord. As I said, my lord, can it be tomorrow?
This qualification is not confidential.
No, my lord, what is the process? What is the process?
Call it after some time.
6 months.
We'll dispose it off, don't worry. Yes, sir.
Please, Your Lordship.
Lord, this matter, my Lord, it's better if I file a detailed affidavit. Because as per the inspection report, there are two components. One is the slab constructed on top of the drain, my Lord, and one is the wall which is exceeding the limit of the land. So, my Lord, a detailed my Lord, affidavit will be proper. Because as far as covering of the drain, my Lord, it really doesn't disturb the municipal, because it's a municipal drain. If it's covered, my Lord, it's good for us.
But he was happening to recover a drain and build on top of the drain.
That is the second component. That is why
happening everywhere.
I'll file a detailed reply 2 weeks.
Mr. From Nombri today submits on instructions that such instructions have been received, and he may be allowed to place the same affidavit within 1 week.
2 weeks.
Within 2 weeks, yes.
Bishop, we have already taken step on respondent number 5.
Yes?
We have already taken step on private respondent number 5.
It's been served.
Still awaiting for the status report, Your Lordship.
You can serve by personal service. So the officer indicates that the notice has not been served as yet on respondent number 5 stamp. Council petition is permitted to effect step by personal service. Yes. This after 1 week or 2 weeks?
2 weeks.
2 weeks.
Hearing item 17.
Yeah, Dr. Todi, where were we last time?
My Lord, in fact, I have argued almost, my Lord, I finished my argument. On the last date, my Lord, only, my Lord, what is left, my Lord, to make payment, the 2 seats I gave your Lordship, my Lord, that how much still they are to pay. That is there, my Lord.
Once the hearing continues for you, like 1 day after 2 weeks, I'll need bullet points.
Yes,
I won't remember. If it's just for the same day, then then I can recall. Yes.
In fact, my Lord, this is, my Lord, in the second round of litigation. In fact, what happened, my Lord, earlier, my Lord, this honorable High Court, my Lord.
I remember now. Only that you didn't want to pay by check, or already paid by cash.
Yes, my Lord. That in fact, my Lord, that was subsequent, my Lord. Subsequently, after about 1 year, almost 1 year, they introduced the system, my Lord. And so far the period commencing with regard to, my Lord.
Now, one thing, Dr. Todi, for the period from 1/10/2008 to 31/12, they paid you 2008, right?
Yes.
And for 1/1/2009 to 31/3/2009, they paid you.
My Lord, in fact, like what happened, these two period, 1st January 2008 to 31st March 2009.
Yes.
This is the period, my Lord. 2 period, my Lord, 6 monthly period.
No, one period is 1/10/2008 to 31/12/2008, correct?
Yes, my Lord.
The next is 1/1/2009
to
31/3/2009.
Yes, my Lord.
And you have paid for both these periods. You have paid for these periods.
Yes, my Lord.
And then now what they have not paid for this period?
What happened, my Lord? In fact, like my Lord, this honorable court, my Lord, already had observed that I pointed out earlier, my Lord, in the judgment dated, Lordship may kindly come to page 46, my Lord. The judgment is 46, page 46. Page, whether Lordship got it, my Lord?
Yes.
Page 46, should I read from the beginning, my Lord? Should I read, my Lord?
Operative part.
My Lord. Page 46, my Lord, the scheme called the Transport Subsidy 1971 has been formulated and notified for grant of subsidy on transport of raw materials and finished goods to and from selected areas with a view to promote growth of industries. The state of Meghalaya falls within the selected area A of the scheme.
in the said area, petitioners Mrs. Meghalaya Foods Products has an industry unit filed letter dated 12/5/2009 issued by the respondent Director of Industries to the petitioner. It has been conveyed that the subsidy has been sanctioned against the claim of the petitioner by the state level committee in its 58th meeting held on 7 May 2009. As such, it has been advised to contact the Northeastern Development Finance Guwahati for necessary disbursement. That is, my lord, they are the disbursing of the net fee, my lord. The types of subsidy period and amount sanctioned are as under. So, Lord, see, may kindly see here down below, my lord, in the chart. This is the earlier period, my lord, that was paid. Then, Lord, see, may kindly come to last two 11008 to 32.
Yes.
Oh, my lord, I am wrong. 110 crores. 11008 to 31/12/08. That is the period 1, and the 11009 to 31/3/09. These two periods must be outstanding. That will remain.
What is outstanding?
Yes, my lord. Okay. Then, my lord, next page, so far as the subsidy for the period 1/9/2005 to 31/3/2009 and 1/4/8 to 36/2008 and 1/7/2008 to 39/2008 are concerned, same has been disbursed in favor of the petitioner. That was disbursed, my lord. What has been stated in the previous page, my lord.
So now your outstanding is the amount of
24
lakhs 74. So on something 1 crore 38.
Yes, my lord. It comes to around 2 crores. Out of that, my lord, some payment has been made, my lord.
Okay.
Not 2 crore, my lord. Some payment has been made.
From this yes, for this period yes. Also.
They are the case, my lord. In fact, what happened? This comes to around 2 crore 20 lakh something. So out of that, they made payment. While making payment, my lord, they again, my lord,
2.2 crores already paid from these two periods.
These two periods, my lord, comes to 2 crore 33 lakhs 44,000, my lord, amounting to on the page 47, my lord, as you mentioned, has not been disbursed. Same has been conveyed to the respondent of 5 by the Undersecretary to the Government of India by letter number because of the expenditure incurred in case on transportation of raw materials finished. Here what happened, my lord? They were sitting at a relevant point of time that, my lord, since the payment was made by cash, so, my lord, cannot be disbursed. Then, my lord, this litigation, my lord, the earlier round of litigation, it appears that for instance.
No, one thing which I'm not clear. Dr. Todi said that this amount 2.33 crores, a portion of it has been released.
No,
not at all.
No, portion has been released. Portion
of 2.33 crores.
Yes, my lord.
How much amount?
Out of that, my lord, the amount has been disbursed. That I am coming to that, my lord. It is.
Lord, I can give the figures, my lord. My lord, principal amount 1 crore 34 lakh.
Please.
Principal amount is 1 crore 55 lakh, 34 lakh, my lord. And interest thereon 63 lakh rupees.
You paid how much? Out of 2.33 crores?
Total we have paid 198.
198. Yes.
Comma 52, comma 054. So almost 2 crore rupees we have paid.
So only some few lakhs are remaining.
Well, because there's an interest component also we have paid, my lord.
Correct.
So total we have paid 1 crore 98 lakh.
So in this 2.33 crores with interest, how much would have come? So how much according to your calculation?
My lord, what
we were stuck last time, Dr. Todi. I wanted to know what is the outstanding amount.
My lord, as per them, my lord, that is including that whatever I have stated, my lord, that is excluding interest, my lord. Whatever they paid, including interest.
Yes.
So, if the interest per portion is separated, then my balance portion, my lord, that amount will come around to that extent, my lord. 72 lakhs for one period, and my lord. But this, let me give again, my lord. This sheet I gave on the other day, my lord.
Okay.
So meaning there
Well,
were
that was clear. That means in the secondary place 72 lakhs plus interest at 12%, and the one's 26 lakhs plus 12%.
26
That is all around you can see a crore or something.
Interest will accrue, my lord, that because as per us is 12%, for them is 8%. So, my lord, 8% on 72 lakhs and 8% on 26 lakhs. Then that matter comes to an end, my lord.
Okay. Yes, please continue.
My lord, that page 47, para 3, my lord.
Yes.
It appears that for ensuring that the object for grant of subsidy is not misused, the checklist for scrutiny of claims under transport subsidy scheme has been formulated as Annexure A and B to the letter dated 2011-2009 issued from Ministry of Commerce and Industry Department of Industrial Policy and Promotion, which inter alia provides that all claims arising from transportation of raw materials and finished goods prior to 10/9/2009 will be examined, re-audited as per checklist A. Point 44, point 35, which is relevant, provides as under: bank statement for payment made transport during the period, payment only by check. Now, precisely the point for consideration is as to whether point 35 for the period 1/10/2008 to 31/12/2008 and 1/1/2009 to 31/3/2009 will apply vis-a-vis payment of to transporters by check. The answer has to be no. This is held by Honorable Court, my lord. The notification has been issued on 2011-2009. Here, my lord, our case is prior to 31st March. That is almost 8 months after. This all happened from, and if we look into 2008, then about after a year, my lord. The period for claim of the petitioner is 1/10/08 to 31/12/08 and 1/1/09 to 31/3/09. During that period, he had no idea that he had to satisfy the conditions of making the payment of the transportation by check. As usual, he has claimed to have been made by payment by cash, same he had done in case of other 3 claims for the period, that earlier period, my lord.
Yes.
The amount of those claims has been disbursed. To abruptly say that the petitioner did not make payment by check for the periods when the notification dated 2011-2009 was not in place shall be illogical, and even though in the notification the condition has been incorporated that all claims arising for transportation of raw materials and finished goods prior to 10/9/2009 will be examined, pre-audited as per checklist A. Point 44 points. Point 35 providing for payment by check is introduced in the month of November 2009. Petitioner claimed to have been made by the payment by cash during the relevant quarter on 31/3/2009. As such, the conditions, if applied retrospectively, will totally be illogical. Now, the question is as to whether the claim for the petitioner is genuine or not. Same position is clarified by respondent number 5, that is net fee, my lord, in the affidavit in opposition by annexing pre-audit report in respect of the transport subsidy scheme sent by Under Secretary to the Government of India to the Chairman cum Managing Director, Northeastern Development Finance Corporation Limited. The pre-audit team during its visit from 19/1/12 to 28/1/12 of 64th SLC dated 35/2011 had at paragraph 67 and 68 dealt with the claim of the petitioner for the aforesaid period. In the remarks column, it is recorded as under. Down below, Lordship will kindly see on the right hand side the reason they have given. Hence, the case payment made to the transporters by units have been allowed. That means because of the period was previous period. Next page, my lord. The other period also the same. That hence the cash payment made to transporters by the unit have been allowed. That is POD team, my lord. Next para 6, my lord. The object of avoiding misuse of subsidy is achieved because the claim of the petitioner has been audited by the Pay and Accounts Officer, Ministry of MSFF. Therefore, there could be no reason for the respondents to deny the claim of the petitioner. That apart, it shall be open for the respondents, if they so choose, to re-verify in case they have any doubt about the audit conducted by the Pay and Accounts Officer. But only to that regard, my lord, that a license was given that you can re-verify. Pay and Accounts Officer, Ministry of MSFF, otherwise the amount shall be disbursed subject to adherence to the norms. What happens, my lord, if your lordship permit me, my lord, I may just make one submission, my lord. Re-verify means, my lord, always it means, my lord, that my lord just to see the calculation, if the total is something somewhere wrong total, that
not the issue of check and cash.
My lord?
Not the issue of check and cash any longer. I mean, it's not an issue of re-examining whether check payment should be made or cash payment.
Yes, that is there, and my lord, not that, my lord, that again, my lord, the whole process on the re-verify means that you only just see with regard to the audit. With regard to audit, my lord, suppose whether they have done anything wrong with regard to the audit, to that extent, what permission is granted, not beyond that, my lord. Petition is disposed of with the direction to the respondents that they shall reconsider the claim of the petitioner in the light of the aforesaid observation, restricted to that. For disbursement of the subsidy amounting 94 lakhs, this amount, and 1,38 lakh for the period 1/10/08 to 31/12/08 and 1/11/09 to 31/3/09 respectively, along with interest from date of pre-audit report, and pass appropriate order thereon, whatever permissible under rules within a period of 4 weeks. Now, my lord, this judgment event, my lord, that also, my lord, it was on 3rd May 2019. 4 years gone by, my lord. Now again, my lord, what they did, thereafter they are sitting over the matter, my lord. Then they said that review, they said that they have been given power to review. There they committed mistake, where, my lord, I am coming to that, my lord. While making payment, lordship may kindly come to page, that is their order, 56.
Yes.
Let's go to it, my lord. Whereas Mr. So and so has filed writ petition number 14, it is 14th matter, my lord. But whereas the condition says that promptly payment has to be made, but already, my lord, almost 10 years, so to say, my lord. So, my lord, this amount is at the Honorable High Court, Meghalaya, owing to disallowance of disbursement of case payment of transport subsidy, and whereas the Honorable High Court of Meghalaya in its order dated 3/5/2019 has directed that the petition is disposed of with direction to the respondents that they shall reconsider the claim of the petitioner in the light of the aforesaid observations for disbursement of the subsidy amount of this amount for this period respectively, along with interest from the date of pre-audit report, and to pass appropriate order thereon, whatever permissible under the rules within a period of 4 weeks. And whereas the department has examined the extant procedure in respect of subsidy disbursement and transport subsidy scheme, the claims of the applicant are first examined by General Manager. The claims of the applicants are first examined by General Manager, District Industry Center at the state level. The recommendations of the GMDIC are considered at the Director Commissioner of the concerned state and thereafter placed before the state level committee on the basis of the recommendations of SLC in accordance with the provisions of the scheme as amended from time to time. Recommendation of SLC is forwarded by the Director of Industries to this department. That is the Government of India, my lord. The department thereafter arranges for pre-audit scrutiny. Based on pre-audit report, further action is taken by department to release funds to Northeastern Development Finance Corporation (NEDFI), the designated nodal agency for disbursement of subsidy in Northeastern region for onward disbursement. This is when a procedure they have stated. And whereas the claim denied for the period 1/10/08 to 31/3/2009, which the Honorable High Court has ordered to review. Here, my lord, they change the word. They said that, my lord, to reconsider, my lord, to verify, re-verify. Here they said review, reconsider and pay. Since the subsidy claimed during the second half of 08-09 is significantly higher than the period of the first half 08-09, which has been denied on account of cash payment. DPIIT reviewed and denied the denial order and agreed to pay as much subsidy as was paid in the first half of the 08-09, that is 134. And under the given circumstance, this should be considered fair and reasonable, because DPIIT don't trust cash payment. Again, my lord, they come to the same place again. That you based on the and here, my lord, in fact, my lord, it is on the actual, whatever the it may be very, my lord, it may be more, it may be less. Based on the subsidy claim of the first half 08-09 made by check, that is 134 plus simple interest 8% per annum amounting this much, total amounting 198 has been released in settlement of subsidy for second half of the 08-09 copy sanction letter. This rate of 8% per annum was the rate as decided by the Honorable Supreme Court in the case of settlement of dues of State Trading Corporation, copy enclosed. This payment of 1,98,52,000 is in order, since the checklist of transport subsidy provides for payment to transporter only by check. Payments made in case are ineligible for reimbursement. It is further stated that under Transport Subsidy Scheme 1971, there is no provision for payment of interest on delayed payment. Now, therefore, the matter of pending claims of Meghalaya products have been examined in accordance with the directions of the Honorable High Court, Meghalaya, and total amount of 198.52 with interest 8% released. So, my lord, now again, my lord, even after the given direction also, Honorable High Court, my lord, they again, my lord, come to the same place, that it is and my lord, they said that whatever was paid earlier, to that extent, my lord, that was paid, but that is not the system, my lord. So, my lord, in fact, my lord, with regard to that, my lord, various judgments I cited before the Honorable Court, my lord, and my lord, my respectful submission is this, my lord. Whatever amount, my lord, was paid, whatever made here, my lord, they have stated the amount, this amount what is paid, and the whatever amount was paid, my lord, and my lord, from the outstanding amount, my lord, plus 8%.
You paid a total of 1.98 crores.
My lord?
1.98 crores is paid to you after this order.
Yes. After this order was paid, my lord, 1 crore 98 lakh, yes, along with interest, along with 8% interest. If we, my lord, if we deduct 8% interest, then
no, you paid 1,34,000 plus 63 lakhs interest.
Yes, my lord. Obliged, my lord. So 130, my lord, 134.55, 396 is the released along with the interest 63 lakhs. That comes to 198, my lord. So our claim, balance claim now.
So after review and re-verification,
we are entitled to get, my lord,
1.98. Yes, principal plus interest.
We are entitled to get 98 lakhs, 98 lakhs 89,084 plus interest.
Interest calculated from which baseline? The time of submissions of bills.
My lord, in fact, my lord, as per the Honorable High Court direction, my lord.
No. Where baseline is taken for what, sir? Now the baseline for calculation of interest is taken from?
Calculation from the SLC, from the, my lord, when
it's approved.
From that approved. So from that time onward. But earlier also they committed mistake, my lord, while because that also calculation mistake was there.
Yes.
Paying interest. So now, my lord, in fact, like whatever interest from date of SLC, my lord, that interest was to calculated, yes, minus interest paid. So that gives the correct picture, my lord.
Okay. Anything else?
My lord, I think, my lord, what my learned friend, my lord, wants to submit, my lord, only my respectful submission that, my lord, that from it, whatever amount was claimed, minus paid, that is the principal actual amount to be paid, and the interest, my lord, from rate of SSLC, whatever paid, minus that whatever remains, my lord, that interest is to be paid.
Give Dr. Mojika. Have you argued? You not argued this one first time.
First time. Loss of sin, the claim, my lord, that is reflected in the order passed by this honorable court earlier, my lord.
Yes.
At page
46.
Well, I'll refer to my affidavit, my lord. Page 56 of my affidavit, my lord.
1 second. Page
56.
Your number? 1.
1.
Your spun number?
1.
1. 25. Yes. Ganesh Nikhare?
Yes, ma'am.
Okay.
But from the table at page 56, my lord, serial number was central interest subsidy. There is no dispute with regard to that, my lord. Page 56.
Yes.
So, my lord, dispute is with regard to item number 2, my lord, central transport subsidy. And this is.
Where are you reading?
Page 56. 56.
Sorry. I'm getting the internal page. R3.
R1. Ganesh Nikhare.
You're reading the High Court order?
Yes, ma'am.
Okay. Yes.
So, my lord, here in the table, my lord, serial number 1, we have no dispute with that, my lord, central transport subsidy.
Yes.
The dispute is only with regard to central transport subsidy, my lord.
Interest, no problem. Dispute with central transport subsidy.
Transport subsidy, my lord.
Okay.
My lord, here you'll also see is paid quarterly, my lord. They have to claim it quarterly, and we have to. Now the first period is 1st April to 30th June, my lord.
1 second. First period is?
April to June.
Yes.
Second is July to September.
Yes.
Then October to December and January to March. So this is 1 year's what is in dispute, my lord, 4 quarters. Now, Lordship, what is remarkable here, my lord? Lordship will see the first quarter is 68 lakh rupees.
So, yes, okay.
Second quarter is more or less identical, my lord, 66 lakh rupees. Then it starts rising, my lord. Third quarter is 94 lakh rupees.
Yes.
And fourth quarter is hopping 1 crore 38 lakh rupees, my lord. Now, my lord, and they don't have any documentary proof in the form of bank statement, because this is a transport subsidy, my lord. The scheme says, my lord, any industrial unit in Northeast, if they bring raw material from outside of Northeast, they are entitled to certain percentage of transport subsidy, my lord. And when this dispatch output, my lord, the finished products to outside to other states, my lord, I think it is up to Siliguri, my lord. Whatever transportation cost is paid by them. That
Not
is
nearest railhead. No.
Nearest railhead, or I think it was somewhere in Siliguri also, my lord. Siliguri is taken as the exit point.
Siliguri.
Now, my lord, so they have to prove that they have spent the money on transportation, my lord, and they have to enclose the documents to that effect. Now, the government said that this kind of documents, the vouchers from transporters, and they indicate that these are cash payment, so these cannot be accepted. But these documents can easily be manufactured, my lord, without actually being spent. They can procure some kind of vouchers from some transporters, my lord, some transport trucks and all that. So that is why the department, what they did, my lord, they rationalized the figures, my lord.
Yes.
And taking the figures of first quarter and second quarter as base, my lord.
1 second. Okay. First quarter is 1/4/2008.
My lord.
236.
Yes, my lord. Second quarter is 1708 to 3908.
Yes.
Third quarter is 110 to 3112.
Yes.
And fourth quarter is 119 to 31/3/2009.
Yes. So you took the first 2 quarters as baseline.
My lord. So we calculated on that basis, my lord, and paid for the third and fourth quarter, my lord. Of course, this payment was made after the order passed by Justice Mir, my lord.
But there's no direction there. They asked you to re-verify.
Re-verify and
now re-verify the amount to review. Verify, that means you audit the amounts. Verify with basis of materials that are already there, not to introduce a new kind of a policy.
My lord, in my humble submission, my lord, this office memorandum is only in the nature of a clarificatory, my lord.
Which one?
Because in 2009, Ministry circulated an office memorandum saying that only bank statement and
whatever it is,
official
like,
payments should be
that
accepted.
amounts to suggesting there has been a lot of defalcation.
But in fact,
I mean, defalcation in the sense of manipulation.
There was manipulation, my lord.
Leading to like a.
And the basis for that is a CAG report which we have annexed in the affidavit, my lord. I just point out a few paragraphs from that CAG report, my lord.
Yes.
But this starts from page 23 of the affidavit, my lord.
1 second.
Starts 23. Relevant portion is page 37.
Page?
The report starts from page 23, my lord. I'll take your lordship to page 37, my lord.
Yes.
From the top, in order to ascertain the extent of checks exercised at different levels by the implementing and monitoring agencies regarding the correctness and genuineness of subsidy claims, compliance to some of the aspects regarding documentation, collateral evidence, timelines of the claims, and transportation by other modes, etc., were checked on sample basis in the states. The main findings of the sample check are summarized in table 2 below. Now there's a table value, deficiencies in documentation and brief description. Sales tax, VAT assessment not available. Out of 120 test check cases, the SLC had passed claims worth rupees 61 so and so crore without availability of state sales tax, VAT assessment, which would have provided corroborating evidence of the size of operations of the unit in 67 cases, 55%. Arunachal Pradesh 10, Assam 27, Himachal Pradesh 2, and Meghalaya also 13, my lord. Other supporting documents not available. Out of 79 test checked cases, claim for rupees 147 crore were passed without other supporting documents, bank certificates, indemnity bonds, NOC from Sales Tax Department. In 77 cases, 97%, Arunachal Pradesh 10, Assam 45, Meghalaya 15, and Nagaland 7. Further, transport subsidy of rupees 17.08 crore was paid to 25 units in Himachal Pradesh, in respect of which annual accounts had not been obtained. No proof of adjustment of outstanding dues of government financial institutions. Out of 95 test checked cases, no proof of adjustment of outstanding dues of government financial institution was available in 64 cases. 66%, Arunachal Pradesh, Assam, Jammu Kashmir, Meghalaya also there, my lord. Then the last item I'll refer, my lord. Case of loading, unloading, handling charges not excluded. Out of 69 test check cases, the guidelines regarding exclusion of the cost of loading and unloading and other handling charges were not adhered to in 17 cases. Assam 3, Meghalaya 5, and Nagaland 9. So there are large-scale anomalies in dealing with the subsidy claims, my lord. So, my lord, page 50 is, my lord, the 2009 guidelines, my lord.
50.
Page 50, my lord.
This is the guidelines.
My lord,
Checklist
so
was
what
fulfilled.
documents are necessary, my lord? See, at serial number 35, we also see bank statement for payment made to transporters during the period. Payment made only by check, my lord. And this was issued on 20th November 2009, my lord.
This 20th November, right?
My lord.
2011.
2009.
This is the change in policy.
It is not, in my humble service, not a change of policy, my lord. This is only to streamline, because this does not extinguish or create any new right, my lord.
Okay. It's not a change in policy.
Well, the policy remains, my lord. We say that because there are large scale anomalies at the state level committee, so to streamline the process, there are no fake claims, my lord. Just to deal with that, we said that you have to, because these requirements in one form or other were already there, my lord, in the scheme itself, my lord.
Where's the check, India? First one check. Where's the checklist? E and B.
Starting 51, my lord, page 51.
Okay.
And page 52, serial number 35. This is the crux of the matter, my lord.
Or also bank statement only, not check payment. Yes.
So when we insisted for bank statement and check payment, they don't have, my lord. All our vouchers, my lord, signed by, it's very difficult to verify those vouchers, my lord, whether they actually incurred those expenses or not, my lord. They are unverifiable documents, my lord. So, my lord, when we did not entertain the claim for, last 2 quarters, my lord, on account of these grounds, my lord, they approached this honorable court, my lord, and Dr. Toti is taking a lordship to the order.
Yes, yes.
But
now re-audit, on what basis re-audit is it?
Well, the re-audit again, we rationalized on the basis of first 2 quarters, my lord. But these are inflated claims. We don't have any basis.
Exactly. How can you suppose suddenly your production rises and you send your goods? Now, any like reasonable nexus, that you can say that there has been some inflation in the bills.
But my lord,
nexus you can call between your assessment and the amount that they have given.
My lord, we rationalized only on the basis that the payments are cash, my lord. Had these been bank payments, my lord, we had no reason to disbelieve them, my lord.
So that means
because they are also defaulting
implying that they have worked the system to their advantage by causing loss to the
that is what CAG report says, my lord. So to get a taxi receipt is something like that, my lord. Like many times we see coming from Guwahati, we get a taxi receipt from somewhere, my lord.
No, that really come from Guwahati. That is different. That is when you really come and you can't obtain from one taxi, another fellow gives it. That's all right. The questions of false certification, but the questions of, in this case, how in writ court can you assess this then? That whether your action is right or wrong. It might be based on some, what do you call it?
Because
might have some foundation.
Because there are no other bases available to us, my lord. It is not possible to verify individually from those truck owners, my lord, the 2009 certificates now, or whatever vouchers they produced, my lord. This exercise was done in 2020.
How will now has the petitioner supplied everything with regard to the the amount of money that allegedly spent by cash all the vouchers are intact. Been passed state level committee, they've examined all that.
My lord, state level committee only saw some vouchers are there, my lord. They did not carry out an exercise to verify whether they are genuine certificates.
They're interested in the more important kind of vouchers.
My lord. Moreover, my lord, what Justice Mir said, my lord, I may just highlight, interpret in my own way, well, few words. That apart, it shall be open for the respondents, if they so choose, to re-verify in case they have any doubt about the audit conducted by the pay and accounts officer. Normally, how do we re-verify the audit?
How do you re-verify, yes?
Because those documents to check the veracity of the vouchers.
Exactly, that's the point that this court is getting to. If they can't verify, how do you expect this court to give some kind of reasoned judgment that's right or wrong?
My lord, that is my whole.
Then what do you want this court to? What kind of direction can we give?
My lord, this is for them to. My lord, that is why we are saying, my lord, we rationalized on the basis.
You have rationalized. I mean, rationalized. They also have given up their arguments, and you rationalized it. But then, like, whether it's right or wrong, whether this bill can ever be verified, and whether they are entitled to it, also, how can the court decide?
My lord, they can establish those vouchers now.
Civil court.
Civil court, my lord.
That's the only course, because otherwise we are at a deadlock. And it's not a position also to say that no, it's wrong.
Moreover, my lord, after this order was passed, we complied with the order. On the basis of rationalization, we paid that amount, my lord, almost 2 crore rupees to them. In the meantime, they filed.
It's just the only thing that will flow like that, because after the court's order, our hands are tied also with regard to any finding.
My lord,
I think that if the order is there for not reassessment, is for re-verification, and you say that the outstanding amount they claims that in spite of the bills.
Moreover, my lord, after the learned single judge's order was complied with, we paid 2 crore rupees. In the meantime, they had filed a contempt, my lord, and we have preferred a writ appeal before the division bench, my lord, against this order, my lord. My lord, that order has some bearing, my lord. At page 72, the order is
of your affidavit. Long order.
1 page order. Short order.
72.
Yes, ma'am.
Yes.
And the appeal is directed against the order passed by the single bench of this court on May 3, 2019. It is fairly submitted on behalf of the appellant union that though the present appeal has been carried, the impugned order has been substantially complied with. Learned assistant solicitor submits that a fresh writ petition has been filed by the first respondent SSC upon not being satisfied with the extent of compliance with the relevant order by the department. Since it is accepted position that the order impugned has been given effect to by the appellant herein, the present appeal can no longer be maintained, though the legal issue involved is left open for consideration in an appropriate manner. Well, the legal issue being kept left open, my lord. In my humble submission, the order passed by the single judge earlier, my lord,
has lost its force.
Lost its force. So,
no, but you can't ignore the fact that it is a continuation. It's the same cause of actions arisen. It's the same thing. Only that they've got partial relief, and now they're going for full relief. That's all.
Well, the remaining relief in my humble submission, they have to establish.
Very difficult, Dr. Tori. Very difficult for this court to come to any conclusive finding on the basis of the reassessment, because there's not disputed facts. It's just strongly on that. They dispute your bills.
My lord,
you have given your bill dispute. It's not a question of certified and accepted bills.
My lord, may I submit, my lord?
Yes.
In fact, my lord, whatever submissions made by my learned friend, my lord.
Yes.
My lord, it is something, my lord, in my respectful submission, my lord, it is very, like, not understood. I cannot understand, my lord, one thing, my lord. The central audit team is by them only, my lord. It is by Government of India. Central audit team is not by state. That aspect has to be looked into the matter, my lord. That Lord Civil can see. Central audit team by whom? Now, my lord.
So you mean exercise should have been done by involving the state also?
My lord Civil kindly sit, my lord.
1 second.
Issue is, my lord, very simple, my lord. What my learned friend is submission, I am making reply to that, my lord.
Yes.
And my lord, under 226, my lord, what is the scope under 226? I don't think there is any scope, my lord. Now, my lord, only one aspect is to be seen, my lord. First thing, that my lord, central audit team is by the central government.
Yes.
And audit team, my lord, audit team, when the audit team is there, when the High Court, even the audit team, my lord, they don't find any infirmity with the audit team. There is nothing on the infirmity with the audit team. Because it's general observation, something different, my lord. If somebody says that there are 7 thieves in Assam, that does not mean I am. 7 thieves, my lord, they are to be, my lord, to be named. Here, what is a general observation, that they are the, Lordship may kindly see, let me read again, my lord, what it says. Page 37. Page 37 says, it is general matter audit team, there is observation matter, how come they nail, how come matter, where is the observation that my party, my petitioner is the evader?
No, this is a CAG report. We're not going by this.
My CAG report is general, my lord. See, it is a guideline. My lord, let me make my.
Dr. Tu, we're not going by CAG report. CAG report makes only after the horse has fled the stable, then they find out discrepancies.
Yes, my lord.
We're not going to go by that. The
yes.
thing is that what the baseline or whatever the basis of the case is that what this court observes and it sees that it's just amounts that have been disputed. And in what manner was audit done, we do not know.
My lord,
and how they rationalize to rationalize the average of 2 quarters, we do not know.
My lord,
how will that serve your purpose? We do not know. How will Illinois serve their purpose to comply the court order and to say we've rationalized it, we have done a re-verification, but whether this amount to re-verification?
My lord, may I submit?
The formula given by Dr. Mozika says that we just taken the first 2 quarters of that year, and because the amounts were less, 67 lakhs and 98 lakhs, we've taken average and given you that money with interest.
My lord,
they've simplified the whole thing.
My lord, may I submit, my lord, one thing, my lord?
Yes.
In fact, my lord, it's a very, very dangerous, my lord, thing to accept it, my lord. If, my lord, if it, otherwise, my lord, my income, my lord, every time, my lord, we are, my lord, liable to file income tax return, my lord, and pay income tax thereon, my lord. My return, my lord, every year differs, my lord, based on the, my lord, the clientele I am getting.
Exactly.
So,
we're not on that, Dr. Toh, we're not on that. Not CAG report, or we're not on the returns that you file, we're not on the bills that you submitted. It's just that this court finds it difficult to give any conclusive finding. But now, I don't think they're right in the way that what they've done. I mean, rationalizing the amounts of 2 quarters. Because it won't take into account what is the exact production. What you've done that, there's no materials to show that. But now the thing is that now coming to you also with those amounts that have been put up by you, how was the court sitting here to verify whether those amounts are correct or not? And yes, like there's a mandamus issue that, that is why in the earlier round they said very safe routes been taken out. Put the responsibility on the respondents, you re-verify.
But they have not re-verified. What they did? Why they did, my lord?
We don't need to argue that point at all. You don't argue that point at all. It's only what can this court do if faced with this kind of situation.
My lord, in my respect to submission, my lord.
Yes, what can the court do?
In my respect to submission, my lord. My lord, the honorable court under 226, my lord, will see, my lord, what transpires from the, my lord, the procedure. As per the, my lord, the policy is the, my lord, the force of law. And, my lord, whatever in the policy, it is, my lord, if there is a, my lord, wrong policy, my lord, suppose the audit would not have been there. My lord, my learned friend is any law is without.
So suppose, Dr. Tory, there's been a total. Anyway, please continue. Yes, we'll end the arguments now.
My lord, in fact, my lord, my respect to submission, my lord. Suppose there is apprehension in the mind of my honorable court, my lord. That, my lord, it has not been done. Then, my lord, if the, my lord, it has not been appreciated in the right manner, in the right mechanism, what is enumerated in the policy, then, my lord, is question of law. And, my lord, it's a mistake apparent on the face of record. It is not a case. It is not a case. In my respect to submission, my lord, which audit team did their job. It was central audit team because they did audit report. After that, my lord, audit what they did. Again, they came to something, it's a bad case, because if they would have raised any doubt with regard to the audit, that audit is not fairly done, audit 3 plus 2 should be 5, they made it 7, that is re-verify. Audit team, my lord, representation of evidence, that is not the scope of the scheme, my lord. The scheme is that you have to audit, and the honorable court has directed, my lord. It is apparently contemptuous, my lord. In fact, when the court said it re-verify, how come they rationalize? Rationalize is there has to be some power vested on them. under the scheme that they have the power to rationalize.
Exactly, doctor. That is what you're coming to the same point. Anyway, heard this Alpha orders.
Our role was quite limited in this process. State government's role was only limited to the extent of verification.
Yes,
of the
we are aware of the functions of state level committee. Yeah. Let's see.
And my lord,
of course, you are disbursing authority only.
My lord, one more thing is there, my lord. In fact, my lord, once the my lord order was passed by the Honorable Court, they recorded in toto whatever they observed by the Honorable Court, my lord. Suddenly, my lord made a U-turn that is not contemplated by the order of the court. Then, my lord, they said it is absolutely high. When it is actual, suppose they doubt, my lord, it is not actual. My lord, may kindly, hey, there is a point. My lord, what is the appearance of the Honorable Court, my lord? My lord, it's my duty to clear it, my lord. In fact, my lord, if they had anything that, yes, with regard to this amount.
One thing which did they involve you in the re-audit?
My lord?
When they re-audited, did they involve you or not in the review?
I have no idea, my lord, because that is
I don't know. Did they call you and did they call you for a hearing, something with regard to when
no,
they?
My lord, no, my lord.
Fine.
Then one more thing is there, my lord.
Yes.
My lord, here, my lord, lordship, since my lordship asked me that what is the solution, my lord. If my lord, after verification, after the re-verification of the audit report conducted by the central audit team, my lord, during the process of re-verification, suppose they wanted that yes, there is some anomalies with regard to the re-verification of the process. That, my lord, re-verification, my lord, your lordship is aware, my lordship sees with the many cases, my lord. Even re-verification, my lord, in the university, my lord, when the exams, students' exam, that is recalculation, not re-evaluation. Re-evaluation, that is the recalculation. Recalculation part of things, suppose there is something wrong, that is not the case. They have not come out in the affidavit that the re-verification, they found some mistake on that.
We've seen that, yes.
Abruptly, my lord, of their
your
own.
Submissions are noted and accepted, Dr. Todi.
Much obliged, my lord.
19.
Yes.
Much obliged.
CAB, my lord.
No, I will pass orders by today.
Much one.
We keep CAB.
19.
Check it, madam.
Wait, please, your lordship. No, I won't take much time, your lordship.
Now we're a dead duck. What are you going to do?
Well, I'll try, my lord. The volume of illegality, malafide, my lord, has been committed in this case, my lord. Hopefully, my lord, I will be able to convince your lordships. Now, my lord, before I start on the facts, very briefly, your lordship is fully aware, my lord, the check gates by these non-tribals and all your lordships. That pursuant to paragraph 8, all these rules were in place. And my lord, one point of time, these issue came up before a bench of this Honorable High Court. And the question came up, my lord, whether the plenary power...
I just 5 minutes, I'll just come back.
My lord, before I start, my lord, this setting out the toll gate in pursuant to the power, my lord, paragraph 8, your lordship. So one issue came up before this honorable court, my lord, whether the plenary power, leasing out the collection of fines and all, could have been leased out to a private party. There one decision, even my lord was associated, as your lordship was done. So ultimately, court said at this point we are not deciding. This is a very fluid situation, where the plenary power, my lord. So, my lord, in this instant case, what happened, your lordships? A tender was invited, my lord. I'll take my lord to page 24. The type copy is, your lordship. Type copy starts from 29, man. Lordship. Now, my lord, this is dated 18th October 2021. The Executive Committee, Jayantia Hills Autonomous District Council, in exercise of the power delegated under Rule 3 of Jayantia Hills District Trading by Non-Tribal 2015, intends to appoint agent for identifying, detecting illegal trading by commercial vehicle of non-tribals, your lordship. Now, my lord, paragraph 2 is regarding submission of the bids. Now, my lords, paragraph 3, my lord, detailed check station, location, etc. are provided. Now, my lord, in the tender, my lord, 2 check stations were notified. One is Mukindur, other is Amrara. My lord, we are concerned with Mukindur, your lordships. We are concerned with Mukindur. Right. Now, my lord, if your lordship come to the next page, page 30, your lordships, page 30, my lord, paragraph 7. My lord, paragraph 7 contemplates, my lord, two-bid system, my lord, comprised of technical bid and financial bids. Now, my lord, the details of the requisites to be furnished, my lord, are provided.
We can skip this, Mr. because we already traveled this journey
briefly. Then, my lord, paragraph 12, it said it should go to the highest bidder.
Yes. Right.
Now, so for these cases concerned, my lord, what happened? Tenders were submitted, including me, there were 3 eligible bidders. Now, first thing they did, my lord, this is very important, the technical bid was open. And after detailed inspection, your lordship, that was reflected in the last judgment. Detailed inspection, they have surveyed my land. Everything was done. Then, my lord, my technical bid, I was declared eligible to participate in the financial bid. My lord. And that part, your lordship, if I will take to the last round of litigation where my lord has categorically recorded this in the judgment. My lord, judgment start from annexure 7. If I can take my lord to page 57. Page 57.
Yes.
Lordship, I'll just read paragraph 12. The above noted judgment has become the benchmark on which such matters are considered by courts and has been followed by various other judicial pronouncements, including the authorities cited by both the parties herein. Accordingly, therefore, by applying the said principle in the considered view of this case, non-settlement of the contract with the petitioner cannot be said to be affected by malafide inasmuch as reason ascribed in the decision dated to appear to be based on factual. However, the only element of concern is the fact that the respondent number 3, after finalization of the bids, had embarked upon the exercise to ascertain the viability of the offer of the petitioner. No doubt the finding reflects the complication that would arise in the operation of the check station by the petitioner. But however, the facts that the decision to not settle the contract with the petitioner, when essentially petitioner had met the criteria prescribed by the entity, deserve to be relooked at by the respondent number 3. So my lord has said, because my contention before your lord, my lord, was this: I had qualified in the technical bid, and technical bid, my lord, assessing the suitability of the land came in the technical bid. That was inspected and I have been cleared. So lordship had come to a categorical finding, your lordships, that not settling him in spite of he having qualified, my lord, that need to be reconsidered. Now, my lord, paragraph 13, if you can take, your lordships. Though the principle equity and natural justice do not operate in the field of commercial transaction, whenever a decision has been taken in public interest, court do not interfere in the instant case. However, to strike a balance, limited interference is called for. Accordingly, the impugned letter dated such as issued by respondent number 4, appointing respondent number 7 as counsel agent, Mukindur, has been set aside. The second bidder, it was settled, lordship had set aside that. Now 14, it is further provided that the NOT did not prescribe specific criteria and requirements to meet the norms of setting up toll station. The respondent number 3 is directed to have a relook at the decision, especially the process thereof, before the decision allotment is taken. So, my lord, here lordship has given them a liberty, my lord. Perhaps my lord had indicated they could, because for the sake of convenience, they could perhaps revise some terms and conditions. That perhaps your lordship had given. Now, my lord, what they did? Now, your lordship, if I can take my lords, on the basis of this judgment was dated, my lord, these dates are very relevant, your lordships, that this judgment was dated, my lord, 26/9/2022. Now, my lord, on the basis of these judgments,
yes,
lordship can come to page 60, my lord. The decision was communicated by this letter dated 26th October 2022 to the writ petitioner. Now, with reference to the subject and letter cited above, I am directed to inform you that the Executive Committee, Jaintia Hills District Council, Juai, in its meeting held on 18th October 2022, has relooked into the matter Mukindur checkpoint station for identifying, detecting illegal trading by non-tribal commercial vehicle without license by High Court order dated 26/9/2022. After deliberation, the Executive Committee has decided that the allotment of the check station may be considered to the highest bidder signatory reader allowed if the location of the land to be used for the purpose of check station is feasible for the check station with levy. Therefore, you are requested to arrange a suitable land with levy that can be used for the purpose of operation of the check station so as not to obstruct, disturb the movement of the river along the national line. Kindly note that you are to comply with the requirement for providing land and levy for operation of the check station within 2 months from the date of the issue of this letter for consideration of the Executive Committee as deemed proper. So, my lord, they have taken a decision to settle it with me, but they have requested me, my lord, to obtain a larger land. Now, my lord, here is the question come. Will it amount to revising the requirement of the tender? My humble submission, no. I have been picked up as a successful bidder, my lord, tenderer. They have picked me up as a successful bidder. And then they have put an addition condition to me. Additional condition says, no, you get a bigger land. So that is an addition condition, my lord, between me, my lord. That has nothing to do with tender. Between me and the district council. Now, I could not have agreed to it, that I have been selected on the basis of whatever you have notified in the terms and condition in the tender. So you could not have put an additional condition. I did not do so, my lord. I am a businessman. I want to have it. I said, I'll do it. And I obtained a larger land. So this is nothing to do with, they had not, lordship has though given them the choice.
No, larger
to revise
suitable land.
My lord, suitable land. Lordship given them a chance, my lord, to revise. They had not revised. They have picked me up, but they have given me an additional condition. I complied with it. I got a more suitable land. Though I am still saying, my lord, original land offered by me, still suitable, your lordship. So he did not want to go into, my lord, all these problems. I obtained a suitable land as decided when I am set up levies. Now, my lord, these I had, next page 61. Secretary Executive Committee, Jaintia Hills, such and such. With reference to the subject and the letter cited above, I similarly have the honor to inform you that I have arranged a suitable land with levy located in Mukindur, left hand side of the national highway while travelling from Juai to Shillong for the purpose of operation of the section. Now, my lord, I obtained a suitable land and these fall on the left hand side. So, my lord, right hand and left hand was not a condition, but since they were insisted in earlier round of litigation, my lord, I ensured, my lord, the land now fall on the left hand side while travelling from Juai to Shillong, my lord. So, that also I complied with. Now, my lord, when I was expecting any your lordship, I have set up levies, I have made investment, your lordship, and this land, my lord, I elaborately come to it. I filed an additional affidavit in reply, my lord. Before that, I'll take my lord to Annexure 10, page 62, next page. This is the cancellation order which I have challenged. The Executive Commission decision dated 14th, recalling the decision dated such and such. Office letter dated 26/10/2022. Madam, I am directed to inform you that the Executive Committee, JHADC Juai, in its earlier decision dated 18/10/2022, had resolved to offer appointment to you to operate the council checkpoint at Mukindur, provided you make necessary arrangement for suitable site to operate the checkpoint. The said decision of the executive committee was communicated to you by letter dated 26/10/2020. In subsequent development, one of the tenderers had issued a legal notice on the ground that if appointment is given to you for operating the checkpoint at Mukindur by changing the site not originally offered by you at the time of submission of the bid, the same would be against the tender document and the term and conditions stipulated therein, and it was impressed upon the executive committee that any action in that regard would only lead to a fresh round of litigation. Therefore, the executive committee in its meeting held on 14/3/2023, upon deliberation and discussion of the matter, had decided to recall its earlier decision dated 18/10/2022, and accordingly, as consequence thereof, the letter under reference above issued you stands cancelled. There is only one reason cited: a legal notice issued by the second highest bidder, whose favor it was settled, which was challenged in the first round of litigation and which was cancelled by your lordships. Now, my lord, again I will come back to the same thing, my lord.
The same person.
Same person. My lord, what interest is? He did not have any custody to issue this notice. And other thing, my lord, again, for the sake of reiteration, your lordship, what I said, there is no question of revising the tender conditions. If they had revised the tender condition and my lord made a private negotiation with me, that would have been different.
Concern about objective, concern about action of the respondents.
Lordship.
In in listening to this, lordship, or making a reason for cancelling your allotment.
This is the only reason. Lordship will take note. Now they have come up with so many reasons. Now, my lord, this is the only reason. A legal notice by an unsuccessful bidder, otherwise successful, set aside by this court, who did not have the locus standi. It is not a case where the tender condition has been revised. No. I, being the successful bidder, I was picked up, and an additional condition they have given. Now, with a successful bidder, if I am picked up for job A, now, my lord, if the authorities say no, you will do B also, and if I agree, there is nothing wrong in it.
It was not question of A or B. Officials just say, okay, this is the job, this is certain modifications or what. There is nothing wrong with that.
There is nothing wrong. It's not a question of revising, my lord. That's what I want to place with your lordship. My lord. Now I'll come, lordship. That's how they have cancelled. Now I have filed this writ petition, while my lord issuing notice, your lordship.
When was it filed?
This was filed, my lord, on 3/4/23.
3/4/23.
Lordship has passed an interim order. Lordship has passed an interim order not to issue fresh tender for settlement of Mukindur check station.
Yes.
Now, my lords, now they were called upon basically in one point that unsuccessful tender had no locus standi, and this is not the revision of the tender condition. So, my lord, the cancellation is bad. And other ground I have taken, my lord, this is a very serious ground. An order issued in favor, my lord, some right has been conferred on me. Then this cancellation was done without even issuing a notice, without hearing me. My lord, that is absolutely bad, your lordship. Yes. So these were the basically 2 points I asked, depending on the reason cited in the impending notification. Now, if you lordship look into their affidavit, my lord. Now, my lord, it starts, relevant parts, my lord, other thing they are simply reiterating, my lord. These are not very relevant. The relevant part will start from page 5, your lordship. Paragraph 7, my lord, page 4, paragraph 7. The reason for not allotting me finally. Their affidavit, your lordship. 7.
Yes.
That with regard to the averment statement made in bracket 12, 13, 14 of the writ petition, the deponent denies the same state as follows. That pursuant to the aforesaid letter dated such and such, petitioner by letter dated inform the respondent that she has arranged a suitable land with levy located in Mukindur on the left hand side of the national highway while travelling from Juai to Shillong for the purpose of the check station. B. That however it was discovered that the same land now offered by the petitioner is the same land which was earlier offered by the second highest bidder, C. Rodolph G. Kendia. Now this is the ground they are saying for cancellation. Whereas the cancellation, ground for cancellation is a legal notice. Now they are saying, my lord, this law I will say, my lord, this law has been clarified by the Supreme Court. Now can you bring additional ground? And what is wrong there? Now what is this I have explained in my affidavit in reply. I will come to that. See, that in the meantime, respondent district council received a legal notice dated such and such, issued by the second highest bidder, see such and such, stating that in the event executive committee accept the proposal of the petitioner, which was never part of the original tender document, the same will vitiate the entire tender process and lead to fresh round of litigation. On receipt of the said legal notice, the respondent district council sought for a legal opinion. Upon thorough deliberation of the entire matter, the executive committee by the resolution dated such and such resolved to recall the earlier decision dated 18/10/2022 and to entrust the chief executive member and the executive member in charge taxation to work out the manner and mode of appointment of the agent of the council who will operate the check gate on behalf of the council on commission basis. The petitioner was duly informed about the recalling of the earlier decision dated such and such. That in the meantime, the respondent district council, while running the check gate at Mukindur, departmentally observed that running a check gate at Mukindur is not feasible. And further, because of the increased traffic and VIP movement, and that the check gate at Mukindur is causing traffic jam every now and then, and that the state government has also instructed to keep the traffic movement on the highways unobstructed. Accordingly, the district council leased a larger plot of land at Claytitsi and started running the checkpoint at the said land at Claytitsi departmentally. That in the decision dated such and such, the chief executive member, executive and taxation in the meeting held on 16/22 further resolved to invite Sri Sivanbontang and Shadap, who are believed to have ability of standing to carry out the operation of the check station. Accordingly, by letter dated, the notice of invitations were issued to Sri such and such for appointment and agent of the district council. Upon scrutiny and screening of their competence, willingness, reliability and integrity, Sri Sivanbontang was found to be fit person for appointment as agent of the council, and accordingly, by letter dated, Tang was appointed as agent of the council for a period of 5 years on various terms and conditions mentioned in the said appointment letter. It is reiterated that the checkpoint is being run departmentally through the said agent who is paid a commission such and such. This is unlike the NAT condition where the successful tender has to be provided his or her own land and pay only the auction amount to the entire collection at the checkpoint goes to such agent. The present check gate has been set up by the district council on the land taken on lease by the district council, and the agent deposit the entire collection with the district council. The agent only get his commission 10%. This arrangement has been done because of shortage of manpower and JCs to man.
So what relief can we give you now?
No, Lordship. No, my Lord. Here I am coming now. Now, your Lordships, what happened in your Lordships? The reason,
they have not informed you.
No, my Lord.
It's been behind your back cancelled. Yes,
behind my back cancelled. And what is the reason for cancellation? Only one reason: legal notice.
Yes,
legal notice. Now, my Lord, what happened when an administrative order is challenged, my Lord, based on the reason cited therein, and the matter is before the court? What the court will do? Well, the court will have to confine, my Lord, on the reason cited in the administrative order. Any other additional points, grounds by way of affidavit, by way of submission is not permissible. And that's what the apex court, my Lord, that's what I'm not writing. Only 2 decisions I'm writing in this case. My Lord, I've given a list of books, Your Lordship. That is a constitutional bench judgment, my Lord. I'm relying on it, and this is being regularly followed even now, Your Lordship. That is 1978 1 SSC 405. Para 8 and Para 43, my Lord. Para 8. Well, that is at page 417. Lordship has got it. My Lord, I'll just read it. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reason so mentioned and cannot be supplemented by fresh reason in the shape of affidavit or otherwise. Otherwise, an order bad in beginning may, by the time it comes to the court on account of challenge, get validated by additional grounds later brought out. We may here draw attention to the observation of Bose J in such and such case. Public orders publicly made in exercise of statutory authority cannot be construed in the light of explanation subsequently given by the officer making the order of what he meant and what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and intended to affect the acting and conduct of those whom they are addressed and must be construed objectively with reference to the language used in the order.
Let's go to 43.
Lordship. Now, my lord, here, my lord, if I can pause for a while, my lord, what they did here? Only on that ground they cancel. I came before the court. Now they came away with two additional things. One, for the first time.
No, one thing. We're not there. We're not at the stage where the orders being improved. That court not look to that by affidavit.
Exactly.
That is
no, my lord.
Only thing is that now the only question is, Mr. Sen, is that they're totally changed circumstances.
Exactly. That's what I meant. That's I want to submit on that, your lordship. Now, my lord, what they did. Now, this litigation was the first round of litigation, my lord, last year, your lordship. Throughout, my lord, they appeared, they filed their affidavit. At no point of time they have ever given a hint that we have a plan now to shift out of Mukindur. Never. Normally, my lord, policy decision law is very clear. Court should not review it. But where it is absolutely irrational, absurd, arbitrary, definitely court will interfere, my lord. Now, here what they have done, first on a frivolous ground, on a litigation they have cancelled. Then they had taken a decision and coming before the court. All throughout these proceedings, they never whisper. They are saying, no, this will result in congestion, we need to shift. And they shifted where? Just 5 kilometers away. And what they did? They inducted some commission agent. That is only they are saying they are running it departmentally. It's not leased out to somebody. Otherwise, that question comes, they should be made a party. So there is no question. These are only, my lord, middleman, commission agent. There is no right as such has been created. So now, my lord, these have been deliberately done, my lord, to frustrate the, my lord, right.
Very clear. But what kind of relief can the court give?
Relief, my lord, lordship will restore that order, my lord, by which they have settled it with.
Close the check station.
My lord, has to be, your lordship.
It's not a subject matter here.
No, lordship. Lordship will see, my lord, when they are trying to frustrate. No, if they are trying to frustrate a, my lord, right accurate, my lord, definitely your lordship will interfere, my lord. Otherwise, my lord, my filing the case and my lord seeking protection from this court, my lord, will become absolutely meaningless, my lord. If your lordship say no, since they have gone this far. Now, with what intention they have gone that far? With a malafide intention to frustrate my claim. So, will my lord not interfere in the exercise of the jurisdiction, my lord? This is a classic case, my humble submission, need to be interfered, my lord. Now, your lordship, coming to page, my lord, that is about natural justice, para 43, paragraph 432. Para 43.
Yes.
My lord, I just read it. Indeed, natural justice is a pervasive facet of secular law where a spiritual touch enlivens legislation, administration, and adjudication to make fairness a creed of life. It has many colors and shades, many forms and shapes, and save where valid law excludes is applies when people are affected by acts of authority. It is the horn of healthy government recognized from earliest times and not mystic testament of judge-made law. Indeed, from the legendary days of Adam and of Kautilya's Arthashastra, the rule of law has had its stamp of natural justice, which makes it social justice. We need not go into these deeps for the present, except indicate that the roots of the natural justice, its foliage, are noble and not newfangled.
Your next decision is what?
Lordship. So what I am saying, my lord, that was done, my lord, without any opportunities, so it wishes. Now, what is your lordship's mind? Lordship, otherwise, my lord, satisfied. Then an illegality has been committed. Now, this illegality followed by other illegalities, my lord. What is that other illegalities? Now, they decided to run it departmentally. Through commission agent, my lord, through brokers or middlemen, they have done it. Now, only because they have taken these steps, which is apparently wrong, arbitrary, my lord. Why arbitrary? This proceeding was before, first round of litigation, all throughout this proceeding was before my lord. Not a time they have indicated that they are planning to shift. This has been done, my lord, only with the intention to frustrate my claim. So this kind of thing, your lordship, my lord, which is a fallout of the illegal action, my lord, needs to be interfered with. Now, my lord, the other point they have raised, they have said perhaps, my lord, cancellation. Though it is not mentioned in the cancellation, in the affidavit they are saying it has been cancelled because ultimately that suitable land which I have offered, this was also originally offered by the bidder with whom it was settled and which was ultimately cancelled by this honorable court. Now, my lord, what happened here, your lordships? As I said, my lord, I qualified under the original
now,
tender
very
condition.
strange, the same person,
I am coming to it.
The same person whose land you've taken over, he's the same person filed a complaint.
Simple. No, he's not his land. I am just explaining. I have filed an affidavit. No, this person offered a piece of land obtaining on lease from a lady. Offered
so
that.
you went and put a lady and you got a very piece of land.
Exactly, my lord.
Okay.
So, my lord, what happened? He offered that land. When it was cancelled, he gave up. That was available. And for district council, always saying this was very suitable. Lordship. So, my lord, what I did, I executed a lease with the lady, obtained that land and offered it. And this is, my lord, nothing to do with the terms and condition of the tender. Terms and condition of the tenders I qualified. This is one an additional condition, my lord. These also I complied with. Now, my lord, these cannot be a reason, my lord, to, my lord, reject my right, my lord, to frustrate my right. Now, your lordship, if your lordship comes to, my lord, I have annexed all those documents, your lordship, with my affidavit in reply.
What is second judgment you're
lordship?
Second judgment you're relying upon?
Second judgment that is relating to power, often asked by your lordship, standard matter, civil code, my lord. That is, my lord, too many laws are there, my lord. I have found out one law, recent law. Now they have referred to all decisions starting from Tata Cellular, Roanoke International, then, my lord, Michigan Robbers, and they have summarized, reiterated, and they made the distinction what are the scope of power of the writ code.
Which judgment is that?
That is, my lord, that is 2022. 1 SSC, page 165. Afflex Limited versus Government of Tamil Nadu. Now, there, my lord, basically,
where is the finding?
Lordship, my lord, there are a few pages, my lord, I finding. What are the scopes? Your lordships.
Long judgment.
It's a little long, my lord. Everything I will not rely on. Basically, I will rely on paragraph 1, my lord. 1, my lord, why some powers retain under 226. That has been explained, my lord, in paragraph, opening paragraph. Opening paragraph, my lord, at Lordship has got it. Page 174. 173, man. Page 173, opening paragraph, if I can read. The enlarged role of government in economic activity and its corresponding ability to give economic legitimacy was the bedrock of creating what is commonly called the tender jurisdiction. The objective was to have greater transparency and consequent right of an aggrieved party to invoke the jurisdiction of the High Court under Article 226 of the Constitution of India. Beyond the issue of strict enforcement of contractual right under civil jurisdiction. However, the ground reality today is that almost no tender remains unchallenged. Unsuccessful parties or parties not even participating in the tender seek to invoke the jurisdiction. Now, my lord, the grounds, ultimately they have referred to all those judgments, and my lord, the grounds on which challenge can be made, they have. Lordship, if I can take my lord to 56. Page, my lord, paragraph 4. You can take paragraph 4. Lordship. Lordship has got it.
Yes.
In a sense, Wednesbury principle is imported to the concept that is the decision is so arbitrary, irrational, that it can never be that any responsibility authority acting reasonable and in accordance with law would have reached such a decision. One other aspect which should always be kept in mind is that public interest is not affected. In conspectus of the aforesaid principle, it was observed in Michigan Robbers, my lord. This is the formulated principle of law. From the above decision, the following principle emerges. The basic requirement of Article 14 is fairness in action by the state. And non-arbitrariness is essence and substance is the heartbeat of fair play. These actions are amenable to the judicial review only to the extent that the state must act validly for a discernible reason and not whimsically for any ulterior purpose. If the state acts within the bounds of reasonableness, it would be legitimate to take into consideration the national priorities. B. Fixation of value of the tender is entirely within the purview of the executive and court. My lord, I am not going to see.
No, understood.
Lordship. And another point. So now here, your lordship, my lord, rational, arbitrary. My lord, can an action be so arbitrary than this? What can be more arbitrary than this? So arbitrary, my lord, without even a notice, on the basis of a legal notice. And after that, hurriedly, what they did, will shift. Normally, my lord, I understand, my lord, policy decision we cannot interfere. All throughout the case, never whimpered that we will go. Now they have opened it departmentally, and they are saying we have engaged, my lord, commission as
It's a question of decision-making process.
Decision-making.
See, that's so your case will come under that.
Exactly.
Whether the decision-making process is
flowed,
vitiated for some reason.
Seriously flowed, man. Why it is flowed? The way they have conducted, your lordship, say they have settled it with me, then they have cancelled on the basis of the, and immediately they have taken a decision to shift it. So these are all what the court is saying again and again here, my lord, in this ulterior motive. And the ulterior motive is very clear here.
Okay, yes.
Lordship, one second, my lord.
I will have it tomorrow.
Huh?
We'll continue tomorrow, yes.
Lordship will continue tomorrow.
Yes, because I'll just do the other matter. You come prepared, because that's the only thing. Did you let him complete his argument? Yes, Mr. Sen, anything?
Lordship, man.
Now, I've understood your case. I think I might be wrong.
No, man, it's not otherwise. Because what I am saying and what is in your lordship's mind, this is all right, this is wrong. Lordship is saying, prima facie is wrong what they have done it. But what happened? Next steps, what happened? They have shifted it. Now they have shifted it, I cannot restore it. My lord, here my case is there. My lord, this is with a ulterior motive just to frustrate my right. And lordship will see, my lord, in the impugned administrative order, there is only one reason. Legal notice. Now they have come up with two more.
That's motive.
That can your lordship go into it? Court cannot go into it. And if they have done it, my lord, lordship will declare them illegal, my lord. It is immaterial, my lord, here whether this is challenged or not.
Yes, we'll have it.
Now, my lord, if your lordship, if I can take my lords to my lord, again, my lord, in the paragraph 2, my lord, do settle position of law in Tata Sona. On what grounds? Para 2 of the, my lord, decision, my lord. Decision that just now I referred to. 2022 1 SSC 165. Yes. My lord, what are the grounds on which court can interfere?
Para 2.
Para 2, my lord.
Yes.
The judicial review of such contractual matter has its own limitation. It is in this context the judicial review of administrative action that this court has opined that it is intended to prevent arbitrariness, irrationality, unreasonableness, bias, malafide. The purpose is to check whether the choice of decision is made lawfully or not, to check whether the choice of decision is sound. No, my lord, here they are on these are the grounds, my lord, limited grounds available for judicial review of a tender matter. No, my lord, here it is, my lord, so irrational, so unreasonable, my lord, so arbitrary, my lord, on the face of it. Even the conduct of your lordship, filing an affidavit, one reason cited, they have come up with two more reasons, which my lord cannot go into it. And two
your
more.
case stands a totally different footing from even other settled law. Also, yes, we'll continue tomorrow. Yes.
Whether as a tenderer, my lord, we don't have a right to not give effect finally to the tender, my lord. That is
one whether see it's what you call inexecutable, unimplementable.
That's it.
They have that also you have to go there also. If it's unimplementable, then maybe we have to give fairly in the joints also to the respondents, because it's a question of public revenue also.
Exactly.
So those things come in the picture also, right? I mean, looking at from your side, yes, it's like the act is it's very, very arbitrary in the sense that you could not comply, even like the very reason that they said like give us suitable piece of land and he resorted to go to the other side again. So that means the entire, even the basis of the tender has been frustrated in the sense that it could not have gone on the basis of your allotment. Because the first cancellation that happened earlier was on the basis of location of the land itself.
No, first, my lord, there is no cancellation. They have not settled with it.
They said no, like, the land on the left side, what on the right side, whatever, is not feasible. And so they gave, the thing is that if they were smart, they should have stuck on to the first one.
Exactly.
And
they have
in a proper manner.
They have settled it. And the only reason, my lord, not any other reason, your lordship. Only reason is the legal notice.
You see, the thing is that highest bidder is not the sine qua non.
Right.
That's all.
And in your judgment also, lordship, I confirm the requirement of the tender condition. Now, if they agree by this, they should have gone for an appeal. They have not gone for an appeal.
We'll continue tomorrow.
Lordship, that Nehu.
Any conclusive? Continue.
Nehu matter is very short.
Yes.
Nehu.
Yeah, that's what I want this matter for your matter.
Yes.
Yes.
My lord, I'm praying this matter to be taken up tomorrow, my lord.
No, we hearing just because of.
I'm sorry, my lord, because he was connected, but my lord, he has to leave again, my lord.
What happened?
Something has
He's gone
come
for
up.
lunch.
No, something has come up in Supreme Court, my lord. So he was on his legs.
Well, let them give an undertaking that tomorrow first of the day they will appear, your lordship. This cannot go on like this, because the kind of thing I will place before your lordship is shocking. I'm telling you, shocking. Otherwise, my lord, normally what happened? Lordship has not granted me a stay. Normally we take our time, file an affidavit. But this is so shocking, and they are in a disinformation campaign, my lord. The entire thing under the scanner in the university, building up undue pressure on the selection committee, on the executive committee. Cannot go on. They have come here with a malafide intention just to get a notice and cause mischief. That's what I am concerned, your lordship.
So they achieved the objective. This matter is supplement list first item.
First item.
After motion.
27. 27.
Yes.
My lord, here
Mr.
again.
Sahai is there.
Yeah. My lord, here actually, this matter was looked after by Madam Karwanlang. She's little unwell for quite a few days. I've not been able to go through the file. Can we have it tomorrow, my lord?
New style of adjournments now.
My lord, the orders will bear. She's been appearing all the...
Will testify to the fact that she's been appearing.
Yes.
I've seen Mr. K. Paul and MSK De Cruz. Then where is next order? Okay, 3rd August. Then next order is...
Lordship will also see that on every date they are the ones who have been seeking adjournment. This is a blatantly non-maintainable petition.
That's what I'm saying. I'm only praying for a day's time, my lord. We can have it tomorrow. I'll just go through the files today, my lord, because...
We'll have it tomorrow. Tomorrow's fixed item. On the prayer, Mr. S. Thapa, who's handicapped due to the non-availability of the instructing counsel. This is matter tomorrow as a fixed item. It is understood that no further adjournment shall be taken. What is the point? I should not adjourn the other hearing then. I thought these other matters were there that will take at least 15-20 minutes each. Anyway, we have to go with the flow, like they say.